All right, so now we're going to talk about doing an actual petition where you're going to be on the plaintiff's side and we're going to go through it bit by bit. This one might be a little bit longer. As I said before, I have attached a template so that you have the proper formatting to be able to use. And you need to make sure to read and replace anything that does not apply to the complaint that you are actually drafting, okay? And that means that you want to make sure that you definitely 100% take out every asterisk that you see. But there's other stuff too that's not marked that we're going to talk about as we go through as well. You probably already know, this whole part up here, make sure that this is in bold. Now, in this particular case, I believe that we have it's the Fulton County, it happened in Fulton County. She lives in Cherokee County, he lives in Cobb County. Again, this is all in the same state. Both parties are in the same state. So we're not going to go to where the incident happened. We're not going to go to where the plaintiff lives. We're going to go to where the defendant lives. So it's going to be, well, I guess I kind of skipped ahead, but it's going to be in the county, like I said, where the defendant lives. But in terms of what court it is, this is where you're going to put in Superior Court or probate court or magistrate court, whatever court it is that you are putting it in. Now you can go to the county website for the individual courts, and you can actually look and see what kind of cases they have jurisdiction of. Then you're going to have the parties' names here. Make sure that the parties' names are in capital letters. Again, do not forget to also have it in bold and to remove the asterisk. Then you're going to have the verses, which is in lowercase letters, also bold. And then you're going to have the roles that the parties play. So plaintiff, defendant, capitalized with just the first letter and the rest is lowercase. Then you're going to have your divider line. Again, it doesn't matter if you draw a line, whether you use parentheses or stars, whatever you want to use just to make it so that you are going and splitting the caption down in the middle at the top. And then we have our civil action file number. Now, in this particular case, we have an initial filing, so there is going to be no civil action file number. So you're going to leave that blank. So you're going to still have the line there, so make sure that there is one because this will be for the clerk to write on once you do the filing. Then we're going to have our title for the document, and it's going to be bolded, underlined, centered, and in all uppercase. And in this particular case, I told you very specifically what to title it in the directions. All right, so make sure that you look at that and know that it's not like petition for the person. It's not like petition for personal injury. Remember that this is what you're asking the court for. So you're basically summing it up into what it is that you're asking the court for. So if you're saying petition for Bob Jones, we can't ask the court to award us a person. All right. You can't, if you say like a petition for personal injury, you're asking the court to award you personal injury. We don't want to be injured. We want to be remedied. So we have to figure out the proper wording for what it is that we are asking the court for. And again, I stated for you very specifically what it is in the directions. And I've marked on your paper and told you if it's not correct. So just make sure that you look at that. Oh, I forgot that I threw a slide in here for you that actually tells you. So it says the title of the document will be petition for damages. Again, because we're asking the court to award us damages for what happened. So go back over here and put in damages. Remove the asterisk. Again, keep it bolded, underlined, all capital letters. Now we're going to have our first paragraph, and this is where we're going to put in the plaintiff's name. Just standard capitalization. You don't have to capitalize their name. Typically, only comes now or now comes is capitalized in this respect. So put in their name, first and last. It's always going to go first and then last. And I meant to say that actually up where I said to put the parties' names. So please make sure that that is the only thing that you use to first and then last. Then we're going to have the attorney's name. And this doesn't always have to be included, by the way. Some attorneys like for it to be included. Some attorneys don't put it in up there. I actually just go ahead and have you do it in the drafts that we're making, just simply because some attorneys do prefer it to be in there. So it's easier to kind of take things out that you've learned than it is to put things in. And then down here we have petition for, and of course it's going to be damages. You want to make sure that it is also in italics, and you want to make sure that there is a capital D on the damages. All right, so petition for damages goes here. All right, and this section is going to be our jurisdictional statements. First is going to be where the plaintiff is a resident. We always start with the plaintiff. And I know that it says on here that they've been a resident for more than 6 months immediately prior. This is only for cases where they would have to have some sort of residency requirement, say maybe like a divorce or something. And it could be the plaintiff or the defendant who qualifies, but I still go ahead and throw this in just because, again, I think it's easier to learn to take things out than it is to learn where things go. So again, you can leave it in there or you can take it out. It's up to you. Doesn't matter to me either way. Then we're going to have where the defendant lives, what county specifically they live in. Then we're going to have their actual address. And then we'll have the type of court, like is it Superior Court, State Court, Magistrate Court of whatever county that court is located in. Now, the one thing that I want to note here is that you can see we have been calling them plaintiff and defendant. All right, so we do not repeat names outside of it being at the top in where the parties are at in the caption, and then that first section where it's like comes now, blah, blah, blah. We typically just leave it strictly at the plaintiff and defendant. Now, you can have multiple defendants who have like the same last name, you know, and then in that particular case, you know, or even just multiple plaintiffs in general, you would then maybe call them Plaintiff Smith and Plaintiff Davis, Plaintiff Jones, defendant, you know, Jones, defendant Smith, defendant Davis. Again, you would then label them by a last name or something. If you have multiple that have the same same last name, you would add an initial for them. So in that particular case, you know, you're doing something to just signal to the court who you're talking about. But we don't add their names in the sense where we have these two people who are the only parties to it. Okay, so don't repeat their names down here. We're going to also make sure that we don't use the plaintiff, the defendant. This is going to take the place of their names. So it's going to be capitalized just like a name would be. So again, they're going to just be plaintiff and defendant. Now you're going to have where they're going to be, the defendant can be served at, right? And you can repeat the address here, or you can say it's, you know, they can be served at the address located or, you know, mentioned in the aforementioned paragraph or in paragraph 2. If you use where you're referring to another paragraph, you're going to capitalize paragraph, meaning just the P, and you're going to spell out the number. So it would be capital T and then WO. Now this is where we're going to begin our argument. And I need to make sure that you understand to please remove any kind of directions that I put in these documents for you. I've been teaching this class since 2023. And I teach it 2 times a year. And every single time, there is always somebody who will leave the directions in there. Every single time. Please do not do that. Remove the directions. You would not want to give something like that to a court, okay? Another thing I also want to point out here is how many people will accidentally have to, they'll go back up to like the number, and then they'll hit enter to go down, to start a paragraph again, and they'll leave it so that it's centered like the number. We don't center body paragraphs. They are left justified always, okay? Sometimes they are justified all the way across, but we do not ever center that. We center numbers, not paragraphs. And then on top of that, I will also have people who will leave it underlined. We do not underline things either, okay? Underlining is used for citations in some formats, but again, we're not underlining things. That is used for emphasis on things. Now, I want to specify that you can make up any other facts that are needed, but you can't change the underlying facts in the hypothetical. All right, so you can't add something that's going to drastically change the scenario. But in this particular case, we have an incident that happened on January 1st, 2023. All right, that part of the information is important. Now, the next part of the information that we have is where Annie was getting on the MARTA train, headed home from a New Year's celebration, okay? Then we have where Annie claimed that she was on the train first and she sat down. We're going to end right there. So let's talk about that for a second. This is where you're going to have to start like marking out the things that don't matter. And in this particular case, she was getting on the train. We don't care that she necessarily was getting on the train because we got to get to the point to where she sat. All right. So she boarded the train and sat. All right. That's it. We don't even care that she was coming home from a New Year's celebration because that's not going to change the outcome of the case. It's not something that's material. It's a very minor detail. All right. So this is where we're going to start tightening up our writing and we're going to be saying more with less. All right. So get down to those bare bone facts. If you can scratch it out, then you don't need it. All right. So again, we just need to know that she got on the train and sat down, and we need her to be on that train first because we're going to establish priority for her. So we're going to come back over here and we're going to enter that argument here. Of course, after we delete the begin argument here, ... Do not use claimed either. Okay. Remember that this document is being the mouthpiece for the client. Okay. So it's already inferred that that's what the client stated. We don't need to tell the court that that's what the client told us. All right. Because we're not writing in that type of a voice. We are writing in a factual voice that this is what happened, as if it was Annie who was sitting there writing it herself. Okay. And granted, Annie probably would sit down and write that she was coming home from a celebration and all this stuff and add all the things that don't matter. But stick with just those facts. Okay. We want it strong, definitive language. Then we're going to go back over here and we're going to go to the defendant. Okay, so we see that he's also getting on the train. So we don't really know outside of what Annie told us as to who was getting on first. Okay, but we at least know that she sat first. So either way it goes, we're boarding her and we're sitting and we've established that priority, right? So now we're going to say that the defendant boarded the train and shoved her out of the way. Now, this is important right here because if she was standing and he shoved her, then that would not be making a place for him to sit, right? Like she had to have been sitting down in order for this to happen. So just remember that you're painting a picture with your words, okay, to show that this happened. Now we're going to come back over here and mind you that I used this particular, part right here to show you to go back and, say number 5, number 6, number 7, and you can just keep on going down the line, right? So this is going to be paragraph 5 where we're going to enter in the defendant's information. And we're going to tell that the defendant boarded and that the defendant then proceeded to shove the plaintiff out of the way. Now, this is where we need to establish our cause of action, okay? Because we've given our facts. Let's give what is now our cause of action, and that is that we have a battery. All right, so we need to go and we need to tell the court exactly what our definition of battery is. And this is one of those places where you guys, I had some of you that were using criminal statutes. It says very specifically that this is a civil battery. So we cannot use criminal statutes for a civil battery. Okay. And this is where also kind of that attention to detail comes into play, because I gave you the definition that I wanted you to use. You could word it so that it's like, pursuant to Georgia law or the Georgia statute says that. None of that stuff like that matters, but I did want you to specifically use what it is that I gave you, which is, I gave you the definition of battery, which you wouldn't put in there. The definition of battery is, you would put something like, Georgia law states that battery is a voluntary act where the person intended to make the harmful or offensive touch. They actually made the harmful or offensive touch and illegal harm occurred. Don't add the rest of the stuff that at minimum, it just, they have to be offended, because none of that matters. The court already knows that part, but the court does want to know what we are relying on to put our case before the court. Okay. So in this particular case, again, weed out the words that you're going to remove and get that information in there into a new paragraph. So we're going to come back over here and we're going to add paragraph 6 and we're going to put that there. Now, before we get to the actual injury part, I should have added another space to point out that you would then do another paragraph. Or you can keep it with the battery one if you want, but you would want to put that something along the lines of, this incident rose to a level of battery because, defendant intended to shove plaintiff out of the way, actually shoved her out of the way, and she was injured as a result. Okay. Now in that next line or that next area, we want to talk about the injury itself. Okay. And in that particular case, we don't want to put on there that she didn't suffer a physical injury, because that doesn't matter. I tell you down at the bottom that at minimum, it just requires that that person had to have been offended. And you can't tell me that Annie would not have been offended by this stranger entering the train and walking up to her and shoving her. I would be so angry, I would be offended that this person felt that they had the ability to touch me like that. So we just have to state that there was this legal harm, that she suffered emotional damage as a result, or she suffered, you can add that there was distress or humiliation. Those things don't change that underlying hypothetical, because the emotional damage is what it is. Okay. So again, you can put in there whatever it is that you want. Now, we're going to come back over here and we're going to add that information in. Unless you added, if you're going to add it in with like it rose to a level of battery and all of that stuff, and you're going to create a separate paragraph, then just go ahead and add all the emotional stuff onto this particular paragraph. Now, we have to talk about the relief. A lot of you guys left off the relief which could be granted. And that's one of the easiest ways to get a whole thing kicked out. You guys would plead it down in the prayer section, but you didn't add it up at the top. And you've got to have it in the actual body of the petition itself. If you don't have it in the body of the petition, you can't pray for it later on. You have to have it to where you've already stated it. So we're asking for, and this is where I don't care what you ask for here. Of course, we're not asking for injunctive relief, because we don't care about we don't think that they're going to interact with one another again. Okay. But what we think is that there's some sort of damages that could be gotten here. You can't have punitive damages unless you have your initial general type of compensatory damages. So this is where you're going to have, damages for pain and suffering. If you're going to say that she lost out on work, then maybe we want lost wages and pain and suffering. Okay, this is where we're going to plead that. And then you can also ask for punitive damages if you so wish. Okay, again, the world's your oyster in terms of this. Now we go down here. And again, please take off the asterisks and start prayer and repeat the important items, because I saw a lot of you left that in there. And again, we don't leave that stuff in there because the court's going to be reading this, right? Except, I'm the court. But nonetheless, the first thing we always want to ask for is an order in favor of the plaintiff, okay? Or whoever it is we're representing. But we want an order in favor of our client, all right? So we want to order in favor of the plaintiff. Then we want to start listing out the other stuff. Now, as you can see, this right here is essentially the same thing as our D section, right? And in this particular case, we don't want that there. We want to remove that line. And I always do that just to kind of see who's paying attention. And if I'm not mistaken, I even told you guys I did this. But this is where you want to start putting in what it is you're asking for. So if you're asking for compensatory damages for pain and suffering and lost wages and punitive damages, then you would have B, an order awarding, or you can just put award plaintiff compensatory damages for pain and suffering, or whatever it is. You can have, if you're going to have the punitive damages, you would put a new line in, and C would become, the punitive damages. Then you're going to have that the rule nisi and be done, and that the court order any and other relief that the court finds appropriate. So maybe you don't argue for punitive damages, but the court says this is so egregious that we absolutely believe that there should be some sort of punitive damages to make it so that the defendant doesn't do this again. And that's where the court can do that. But if you don't ask for other relief that the court finds appropriate, the court's not going to just give it to you. So we always leave that in there as our very last thing. Then we go to the date, and remember that the date has to be like the 4th day of whatever, and it's for TH, day of the month, comma, and then the year, period. A lot of you are leaving out the commas and the periods. Then we come down here and we enter in the attorney's name. And we typically enter an attorney for plaintiff, attorney for defendant. You can just leave attorney if you want to. I don't really care. Then we're going to enter the address. And again, please remove enter address, and please remove the parentheses. Write it out like it is on an envelope. We want the street address. On the next line, we want the city, state, and zip. And we also want to make sure that we include the lawyer's bar number. And then last but not least, we want to make sure that we absolutely do not sign this, because this is for the lawyer to sign. Okay, that's pretty much it. And hopefully it makes some sense to you guys on how to kind of word things and format it. Just let me know if you have any issues. Bye.